Okay, there is an update in the new H3H3 case. This is the Triller Inc. v. Filmdaily case. And if you recall, Filmdaily was the first named defendant and H3H3 was one of the last. And there's been a lot going on here, but before we get to the docket update, let's go over your reaction to some of the issues with the case and the claims. I've brought up the comments here, and we're going to go over a couple of these comments. Kidsock TV says, you can see that H3H3 showed screenshots of the fight and a very small clip. The whole fight was 58 seconds anyway, but the whole broadcast was a lot longer. I don't think they specified just a single fight. H3H3 played it off of a YouTube video that was already up. They did not upload it. This is going to be good. I see another win for H3H3. If he was making criticism and commentary on even the heart of the fight, that still sounds like he has a good fair use argument. But if he got the YouTube video knowing that it was an illegal stream, there's at least something that's going to need to be defended there, and I really couldn't tell you which way that's going to go. JosuÄ C says, this lawsuit makes no sense at all. File a claim at YouTube and take the clip down. Suing for a clip of a minute or two of fight is absurd. I agree. Now, the copyright owner does have the right to decide how to handle their copyright enforcement effort, but yeah, there is a valid question. Maybe not a legal claim, but it's a valid question. Why didn't you send a DMCA takedown? This makes it look like they're just after the money and not after the minimizing of the exposure of these illegal streams or whatever. If I was defending, I would say, obviously, they don't consider it to be an illegal stream because they didn't take it down. I don't know how far that would get me, but that would be an argument. Fat Cat says, if you're a person who paid that $50 to watch the pay-per-view, I could see where they would find it unfair that everyone else got to watch it for free, not even having to wait a full week afterwards. Yeah, the copyright owner does have the right to prevent people from seeing it for free if it's a pay-per-view event. That's allowed. Whether or not we like it, sure, we can discuss that philosophically, whether copyright should not be that way, but that is the way copyright is written. If they want to publish it only to people who've paid for it, that's their prerogative. Blitz of Chaos Gaming says, yes, Leonard, Ethan only showed a couple minutes of the 87-second fight. Yes, well, I didn't know exactly how long the fight was because I haven't watched it because I didn't pay $50 to watch it. So if he showed whatever of the fight, part of copyright fair use adjudication is how much did he use, and was it only enough to make his transformative fair use purpose, or was it more than necessary? And that will go into an analysis of that. PJQ says, Ethan said he watched a pirated version, otherwise what he showed is a fair use. Wouldn't they have to prove he watched it that way? Wouldn't it matter that he's not hosting? It will affect the damages claim. If he used an illegal stream to get the content for the fair use, I'm not sure how a judge would rule on that. Sure, you used an illegal stream, but there's also some exceptions in copyright. They're called exemptions, and they're done by the Librarian of Congress. The illegal streams are usually not the way to get fair use material, but it could fall under an exception. I'm trying to recall, without looking it up, what the exemptions would be. There are exemptions for cracking CSS, or I forget what the Blu-ray encryption is. But you have to know those exemptions, and they're usually only for academia to do. So I'm not sure if Ethan would qualify under those exemptions. But yeah, watching an illegal stream and then making a fair use out of what you watched is probably less of a copyright infringement than not making a fair use at all. So that'll affect the case. Brandyn Lynch says, it appears H3H3 did upload or use someone else's unlisted YouTube video upload and unintentionally distributed the video. During the live stream, the video of the fight they were watching was clearly an unlisted, publicly accessible video, presumably uploaded to the H3H3 podcast channel. That video has now been marked as private, so I have no way of knowing which channel. So yeah, the waters are a little muddier than just Ethan made a fair use and therefore this copyright infringement claim is BS. It's a little less clear whether it's BS or not. But there is an update in the case. If I go to the court listener website, go to the recap archive, which is a backward spelling of Pacer, and you can even see that they do like a mirror thing here. You can see the court docket for free, I believe. The complaint was filed April 23rd, and then a bunch of summons were requested for all of these weird parties. There were lots of parties in the lawsuit. And something that I forgot about and I skipped over last week, but I did point out, there was a claim for conspiracy which tied all of these defendants together, and I wondered aloud, how could this be a conspiracy? I doubt all these entities worked together. After all, I mean, you've got Filmdaily, Online to Live Stream, Access TV Pro, you've got all of these different companies who are claimed to have been conspiring with one another. What I forgot about was, if they didn't conspire with one another, why are they all in the same lawsuit? There has to be more to it than just a copyright claim against everybody, but they're different copyright claims. They're for different transactions or occurrences. The only commonality is that they all copied the same thing, not that they all worked together. There are two rules of federal civil procedure that either require joinder of parties or allow it. There is the permissive joinder of parties. Parties may be joined as defendants if any right to relief is asserted against them jointly, severally, or arising out of the same transaction, occurrence, or series of transaction or occurrences, and conjunctive, any question of law or fact common to all defendants will arise in the action. Well, very arguably, these defendants did not all commit the same act if we take that conspiracy out of it. And so if we just assume for a moment that there was no conspiracy between all these defendants to act by copying or distributing or streaming the fight, then they're individual claims. Meanwhile, Triller Fight Club has asked to expedite discovery. Expedited discovery means that the court grants the discovery of relevant evidence, which means sending a request like a subpoena and getting information back, or interviewing witnesses under oath, that sort of thing. That normally doesn't happen until later in the case. So expedited discovery is where you ask the court for permission to conduct that discovery out of order, you know, bang, 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 out of order, order in the court. This is literally the procedural order of the court, and so that they're asking to go out of order. Looking at their proposed order, expedited discovery they are asking for is to learn the nature and extent of the unlawful activity the plaintiff complains of, I think in furtherance of some kind of preliminary injunction or something. And the judge has now ruled on that, and I think you'll find this interesting. So let's go over this 4-page order to show cause. The court previously ordered plaintiff to show cause why one or more of the defendants should not be dropped from the case for improper joinder, as we just went over. In issuing the order to show cause, the court notes that the complaint alleges that plaintiff is informed and believes, and therefore alleges, that the actions, omissions that serve the basis of this complaint were undertaken jointly, and with the consent, conspiracy, cooperation, and joint participation of all defendants, which really doesn't sound plausible. But okay, they allege it. The complaint also alleges that at all times mentioned herein, each defendant was the agent, joint venture, or employee of each and every other defendant. That, again, that they all worked together and that they were all employed by the same entity. So h3h3 was working for those other websites, and Mike, what? And in doing the things alleged in this complaint, each defendant was acting within the course and scope of their agency, because if they weren't, then the vicarious liability does not apply there. As the court explained in its order to show cause, other than these conclusory allegations, the first amended complaint does not contain any well-pled facts that plausibly support even an inference that defendants acted jointly. Instead, it appears that plaintiff has improperly joined its claims against multiple different alleged infringers who have no apparent connection with one another and who have allegedly infringed plaintiff's intellectual property rights by making the broadcast available on separate websites controlled by separate defendants. The complaint does not sufficiently allege, identify, or explain any relationship plausibly between all of the defendants. And why would a plaintiff do this? We can speculate. I can't speak for them. This is just my professional opinion, but it's $400 a pop to file these lawsuits, and you then have to maintain a bunch of individual lawsuits. So if the plaintiff can get away with one lawsuit against a dozen individuals, that saves them the time of having to file 11 other cases and pay 11 other filing fees, and then the extra attorney's time for all of that, and then the administrative costs and personal involvement with having to maintain 11 different actions. Those 11 different actions or 12 different actions could get assigned to different judges, and then you have to deal with the different rules that each judge has, because while the judge can't change the rules of procedure, the judge does have discretion to request certain things, like I want a courtesy copy of this, or I want you to have 7 days for that, or 14 days for that. And so you have to maintain all of that, and you can make mistakes. So it's a little bit of risk and a little bit of exposure for a plaintiff's attorney to then file 12 actions instead of one. But that's not how it's supposed to be done. So the judge calls them out on it. Plaintiff filed a response to the order to show cause and an expedited discovery application. As part of its response, plaintiff requests leave to file a second amended complaint. Plaintiff's ex parte discovery application seeks leave to serve subpoenas on third parties to assist plaintiff in uncovering the true identities and locations of defendants, which plaintiff claims it needs prior to filing a motion for a preliminary injunction. Plaintiff additionally contends that the expedited discovery it seeks would assist in responding to the court's order to show cause. The court then goes over the permissive joinder rule that we just talked about, and that's the rule right there. They must arise out of the same transaction or occurrence. They must have joint or several liability, and a common question of law or fact to all defendants arises. The first prong, the same transaction requirement, refers to the similarity in the factual background of a claim. The plaintiff adds an allegation in the proposed second amended complaint that plaintiff is informed and believes, and therefore alleges, that certain defendants were aware of and informed their subscribers, viewers, fans of the existence of other defendants' illegal uploading and distribution of the broadcast, thereby demonstrating defendants' common enterprise. The judge says, nowhere in plaintiff's response does it provide examples of how one or more of the unspecified defendants informed viewers of other unspecified defendants' distribution of the broadcast. Instead, as it had previously, plaintiff relies on the barest legal conclusions to support the joinder of multiple separate entities without any well-pled factual allegations. That's Federal Rule of Civil Procedure 8. You must have jurisdiction, a claim for relief, and your factual allegations must be well pled. It just means you have to have sufficient allegations to put the defendant on notice of what the claims are, but it must be based on facts, not legal conclusions. You can't go into court and say, I accuse you of copyright infringement, I want money, you're in the right jurisdiction, goodbye. That's not enough. You have to say, you downloaded my copyrighted material, this is what you downloaded, this is when you downloaded it, I want relief, here's jurisdiction, have a good day. And at some point in there, when you have enough facts, that's considered to be well pled. In arguing that the broadcast itself is the common transaction or occurrence supporting joinder of defendants, plaintiff appears to have shifted the analysis solely to its copyrighted material rather than to any common facts concerning defendants' alleged infringement. Nothing in plaintiff's response provides any well-pled facts or other indication that defendants did anything other than operate independently of one another. By attempting to join defendants in a single action without any facts to support joint action, plaintiff increases the risk that the conduct of one defendant will be wrongfully attributed to another independent defendant. Put simply, the court provided plaintiff with an opportunity to provide the court with some evidentiary basis to support its conclusory allegations supporting joinder of these defendants. Plaintiff's failure to provide any such evidence and its ex parte application for expedited discovery indicates that it currently lacks the facts to support joinder and calls into question the adequacy of plaintiff's compliance with its pre-suit investigation obligations under Federal Rule Civil Procedure 11. Rule 11 is, of course, the rule that requires parties, particularly attorneys, but also unrepresented plaintiffs, to do their due diligence. This says that when you make representations to the court, you must be making the representations not for an improper purpose, that the legal contentions and claims and defenses are warranted by existing law or a non-frivolous argument for extending the law, that the factual contentions have evidentiary support or will have evidentiary support after a reasonable opportunity for investigation, and denials of factual contentions are warranted on the evidence, which we generally take to, we call it due diligence. You have to have some bases for your claims and defenses. And when you sign your name to the papers, you are putting yourself within the consequences of Rule 11. The court additionally concludes that plaintiff has failed to establish good cause for the expedited discovery. To justify ex parte relief, the evidence must show that the moving party's cause will be irreparably prejudiced. So irreparable harm is the standard, or irreparable prejudice, if the underlying motion is heard according to the regularly noticed motion procedures. What does that mean? Ex parte means without the other party. It's a court. Normally both parties get to weigh in on motions, and they filed this motion ex parte, but we know who all the defendants are, so why shouldn't the defendants weigh in? Sure, they have these John Does 1 to 100, maybe that's what they mean, but those other parties that are somehow joint are now being treated like they're not maybe so joint because the plaintiff doesn't think they need to put them on notice and let them respond to the motion for expedited discovery. There's, 10 or 12 different defendants in the thing, so that means 10 or 12 different responses, and that means the plaintiff has to respond to the 10 or 12 different responses if the defendants choose to respond. So maybe they're just trying to get around that, and that doesn't appear to be working. Additionally, it must be established that the moving party is without fault in creating the crisis that requires the ex parte relief. In determining whether good cause justifies expedited discovery, courts commonly consider factors, including 1, whether a preliminary injunction is pending, 2, the breadth of the discovery requests, 3, the purpose for requesting the expedited discovery, 4, the burden on the defendants to comply with the request, and 5, how far in advance of the typical discovery process the request was made. Plaintiff asserts that it requires the third-party discovery to identify the defendants so that it may file an anticipated motion for a preliminary injunction. According to plaintiff, the preliminary injunction is necessary to prevent the irreparable harm of defendants continuing to offer the broadcast without authorization. Plaintiff does not, however, explain what irreparable harm it continues to suffer from the availability of copies of a live sporting event that occurred a week ago, the outcome of which is publicly available and lasted less than 2 minutes. So some of your comments were right on point. Why are they asking for a preliminary injunction to prevent irreparable injury when it was a live sporting event? And really the irreparable injury is monetary damages, which monetary damages is not irreparable injury. What is the remedy? What is the reparation for monetary damages? It's monetary damages. It's right there in the definition. So the plaintiff is maybe getting ahead of itself, is what the court seems to be saying. Plaintiff therefore fails to establish the emergency necessary to support the consideration of plaintiff's request to conduct expedited discovery on an ex parte basis. As a result, there is no justification to allow plaintiff to go to the head of the line in front of all the other litigants and receive special treatment. For all the foregoing reasons, the court therefore denies plaintiff's ex parte application without prejudice to its being filed as a regularly noticed motion. That means the defendants will have a chance to be on notice and respond instead of it being a one-sided motion. The court additionally concludes that defendants are misjoined. Because the proposed second amended complaint does not cure the misjoinder, the court denies plaintiff's request for leave to file the second amended complaint, again without prejudice to any efforts to seek amendment in a manner consistent with Federal Rule of Civil Procedure 15, which is about amending your complaint. Pursuant to Federal Rule of Civil Procedure 21, misjoinder of parties is not grounds for dismissing an entire action. Instead, on motion or on its own, the court may at any time add or drop a party. Where there is misjoinder, the court can generally dismiss all but the first named defendant without prejudice to the institution of new separate lawsuits against the dropped defendants. Accordingly, the court thus drops all defendants except Filmdaily. This order does not limit plaintiff's ability to refile its claims against the remaining defendants in separate actions. So that means that H3H3 is dropped from the Triller versus Filmdaily case, and the plaintiff has to refile their lawsuit separately against the other defendants, including H3H3 podcast, and I think there was a second H3H3 named defendant there. So, in a sense, that's the end of the Triller v. Filmdaily H3H3 lawsuit, because a new Triller v. H3H3 lawsuit would have to be filed. So we're watching out for that and see if the plaintiff files one. Maybe they already have, and we haven't seen it yet. This just happened on May 6th. So that's interesting. That was the update of what's going on with the H3H3 case, and I'll keep you updated if there's a new lawsuit filed, or if there's more activity in this lawsuit that involves H3H3, or maybe if there's just an update in general about the case. So I think that's a really funny way to have the case dismissed. It doesn't really mean that Ethan and H3H3 can breathe easy. It does mean that they get a little bit more time to prepare for whatever might come next, and we don't know what's coming next until the plaintiff does it. And a quick search of my legal research systems, there's no new Triller v. H3H3 case yet. So let me know what you think of that in the comments below. And that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Floatplane and on twitch.tv/lawfulmasses, live on Sunday mornings at 10 a.m. Eastern Time. This is a community-supported channel, which means I need your money. It takes time and effort to make these videos, and in order to make room in my life, I need to also have support. So I really appreciate your support on patreon.com/ljfrench or sponsors.com/law. You can support the channel through YouTube memberships, or you can support the channel through Floatplane subscriptions. Thank you very much in the month of May to the following $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn, Abel, Torpedan, RDHDragon, Earthbound Star, and ShadowTycho. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. You're all on the LED tablet behind me. I love you all. Thank you for joining me. I'm Leonard French. I'll see you in the videos that drop and the comments below. Bye. 11-1 says, we are suing these business entities and Mike. And Mike is like, oh man,